So I hope that doesn't interfere.
I'm still working it.
Okay. All right, good. As will the court. So
okay, thank you.
We'll conduct
this is SJT Express. And Jimmy Maynard stepping into court for the very first time in a tort automobile case where liability isn't even contested. That shifts everything to damages, deadlines, and strategy. The real fight starts now.
That's Incorporated and Jimmy Maynard, defendants, case number 2025 CV151. Beginning with plaintiff's counsel. Would counsel announce their appearances for the record, please?
Yes, Your Honor. May it please the court, plaintiff's counsel, Grace Haid, appears via Zoom. Stuart Simmons, Simmons & Simmons LLC, appears via Zoom. And I would just note for the record that Ms. Haid is appearing here in my office and participating in this call as well, Your Honor.
Very well.
Also appearing, Your Honor, is Brian Williams on behalf of plaintiff counsel with Mr. Simmons and Ms. Haid.
Thank you. Defendants?
Suzanne Bruss appearing by Zoom for defendant SJT Express, Inc.
And Alex Schmidt of McCausland, Barrett, and Bartalos appearing by Zoom for defendant Maynard.
All right, this matter comes before the court for the first time. This is a tort case, automobile. I'll address defendant's counsel. Is the question of liability contested?
No, it's not, Your Honor. My understanding is that liability is clear in the case. And so I'm not aware that we are disputing. I think in the answer we did indicate that we denied liability, but after an investigation, I don't believe that we are disputing liability.
All right, very well. So it's essentially a damages case then. I note that counsel has already begun some formal discovery in the case. The court certainly likes to see the case move along. I'll just ask plaintiff's counsel first. I'm inclined to set some deadlines in this case. Do you believe that a 6-month from today discovery cutoff is appropriate?
Your Honor, just as some background, the parties, we did participate in a scheduling conference call on last Friday to visit about these things. So the court is aware. We have tried to visit about some deposition schedules and things like that. But yes, Your Honor, I believe that would be appropriate. We can make this.
All right. Does the defense agree?
Yes, we do agree, Your Honor. We discussed a schedule on Friday and we were in agreement on that.
All right. September 2nd, 2026 is designated by the court to be the discovery cutoff. I'll expect all discovery to have been complete by that date. I anticipate that both plaintiffs and defense anticipate having experts.
Yes, sir.
Yes, Your Honor.
All right. Then I would establish a 60-day deadline, or essentially 2 months from today. I'll say May 1st, because I know May 2nd is a Saturday. May 1, 2026 is established as the plaintiff's expert designation and report deadline. And then 2 months from then, which would be July 1, the defense deadline. I don't anticipate that there's going to be a dispositive motion in light of the concession regarding liability. Is there any other type of summary judgment or dispositive motion contemplated by the plaintiffs?
No, Your Honor, we're still investigating. There's some records that we're investigating as to the whereabouts of it. There may be a motion for punitive damages on this case. That would be the only additional motion we would have. It's not dispositive. However, it would be something we'd have to file before the pretrial.
Okay, very well. Any statement regarding motions to be filed by the defense?
Well, if there's a punitive damage motion, very likely we would have a motion for partial summary judgment on that claim.
All right. The court will establish a deadline for the filing of any such motion to be 1 month beyond our discovery cutoff date. It's currently been established for September 2. So I'll establish October 2 as the deadline for the filing of any dispositive motion. And that would include a punitive damage claim motion.
To make sure I understand, Your Honor, you said the cutoff, would that be from my dispositive motion would be October 2nd, or would that be for their dispositive motion on my motion for punitive damages?
Well, a motion needs to be initiated by October the 2nd. Obviously, if that triggers the need for a corresponding motion, obviously that would be in the nature of a reply or a response. And so the court would allow additional time.
Got it. Thank you.
Within the rules. With that suggestion, I'm hesitant to even set a pretrial date in this case. I will let counsel know mandatorily you must participate in good faith in mediation at some point. I will require it. I don't see that this is the kind of case where you're likely to be so far apart that it would be unrealistic. I think that in good faith, perhaps at some point, there might be a settlement reached, and I want to at least explore that possibility. Now, the timing of it, though, I want to leave open to counsel. You'll be in a better position to know what the appropriate time frame might be. Perhaps a time to avoid some future expense, for example, or you feel like that you've done enough discovery that you have a handle on things where you can then participate in mediation. I hate to set a deadline other than I will require that the mediation be completed prior to any pretrial conference date, which is eventually set in the case. Again, I'm a little hesitant without knowing if dispositive motions or even the punitive damage motion would be filed in the case to set a pretrial conference, but I can do that if counsel requests.
I don't think it's needed, Your Honor. I think it's fine.
All right, but I will set a status conference date because I do not want to lose track of this case. So I'm going to look at what our deadlines are here. I think November is probably the month I'll want to review the case. And I think actually that's a month where my calendar remains relatively open. Monday, November 16. Let's do 11 o'clock again, if counsel are available at that time. November 16, 11 o'clock by Zoom. It'll be a status conference. I'll want to see exactly where we are on the case with the perspective of all parties, and then do further scheduling as may be appropriate at that time. Again, by Zoom, Monday, November 16, 11 o'clock a.m. And according to my calendar, that is Revolution Day in Mexico. So I hope that doesn't interfere.
I'm still working it.
Okay. All right, good. As will the court. So
okay, thank you.
We'll conduct our status conference Monday, November the 16th, 11 o'clock a.m. Now, we've covered some ground here, but I'll ask plaintiff's counsel first. Is there anything else that you believe needs to be addressed at this conference?
No, sir. I think we covered it. Thank you.
Anything from the defense side that the court needs to contemplate?
Not from me, Your Honor.
Very
Not
well.
from me.
I will need a volunteer to draft an appropriate order, scheduling order stemming from today. Do I have such a volunteer?
I'll do that.
Ms. Bruss, thank you. I appreciate that. And if you'll get that circulated with opposing counsel in due course.
All right.
All right. Good luck. I hope you can continue to work together well to work on this case.
Thank you,
There's
sir.
nothing further at this time. The Hayde and Maynard matter will currently be in recess, and this meeting may be ended for all at this time. Have a good day, counsel.
No fireworks, no objections, just structured deadlines, expert designations, mandatory mediation, and a firm status conference set for November 16. With liability conceded, this case now hinges entirely on damages and potential punitive claims. Will mediation resolve it, or will motions escalate? Like, comment, and subscribe.